Good afternoon everyone, welcome to today's Sessions with Sarah, where we talk about different family law issues that may be faced by couples and things to consider as part of your family law separation or potentially even before entering into a relationship. For those of you who don't know me or haven't joined one of these before, I'm Sarah Coombs. I am a partner here at TBA Law and I do a lot of family law work. We do have offices at Romsey, Seymour and Nagambie and Wallan as well. And so we're available right across that northern area for people who are having issues in this area. And today we're discussing what to include in your divorce agreement. This can obviously be very overwhelming when you separate with someone to consider different things like this. It's really important to make sure that you look at all your assets and liabilities to determine what needs to be included, and that's why it's really essential to get family law advice when you can. So there are many different things we consider when we look at a divorce agreement. The first one is normally a party's assets, so things they actually own that need to be separated between them. For many couples, the main asset that they hold is their home, the family home, perhaps an investment property, something like that. Investment properties as well, with both those properties, it might be the mortgage secured against it as well that comes into play. It might be bank accounts, it might be cars, it might be shares in a business. So all different types of assets you can have. It could be blocks of gold that you keep under your bed, something like that. They're all assets, they all need to be considered, and you need to think about how you're going to divide them up. One common question we get is about furniture. So with furniture, people often attribute a lot of value to it, but the reality is often it doesn't hold that much value. It's normally more of a garage sale value than perhaps what you actually paid for it. So you need to consider the assets and how they're going to be divided. When considering whether you're going to keep the house or not, you need to consider whether you're able to refinance the property into your sole name potentially. With cars, you need to make sure that car registrations are transferred. With bank accounts, you need to make sure they're divided or closed if needed. With shares, there needs to perhaps be transfers. So there's a lot of different things to consider there about how they're going to be divided and what's a just and equitable outcome, which is that division of the assets. While assets are probably the nicer part to divide up, the debts can be even harder. So these debts could be, like I said, the mortgage secured against a home loan. So sometimes you might have to sell a property to pay out that home loan because simply neither party can afford to take on that home loan by themselves. It might be credit card debt is another very common one we see. So parties who've accumulated a lot might need to pay that out, or one party might take it on and the other not. Personal loans, car loans. Car loans normally stay with the car they're associated with, but that's not necessarily true in all cases, so that's important to determine on a case-by-case basis. Another big one we see a lot of is HECS debt. So for people who have higher education, sometimes have a significant amount of debt, and that can factor into what someone gets as their overall percentage if they're taking on that debt. The last of the really big things we consider is superannuation. A lot of people fail to consider superannuation purely because it's such a in the future prospect, something they're not looking at doing it for quite some time. However, it is really important, particularly when one party has taken time off work in order to be the primary homemaker and carer of the children, that those assets are just and equitably divided. Super normally requires some sort of formal agreement in order to divide it, because the super fund is the one who actually needs to split that super. Super does tend to carry more weight the older you get, because the closer to retirement you are, the less chance you have to accumulate super. Another thing you need to consider is potentially some long service leave entitlements or annual leave entitlements a party has. So particularly if one party has the ability to take that long service leave and have income, potentially have income coming from another source. It's a little bit more obscure, it's more of a financial resource than an asset itself, so it's very important to get legal advice on that. Compensation, inheritances and large lump sums. These can be taken into account in a divorce agreement, particularly when they come into the relationship right at the very end and there's no children. So there is a chance to have those excluded potentially from the asset pool on the basis that they were a very late contribution. So they're the 5 main things to consider when doing a property pool split. Obviously it is very different on a case-by-case basis and depends what your individual circumstances are. And for that reason, we do recommend you get legal advice so that all those nooks and crannies can be explored. With your divorce property settlement agreement, these can be finalised in one of two ways: either a consent order, which is when parties come to an agreement, they take it to court and the court makes that order based on what the parties agreed to, or a binding financial agreement. A binding financial agreement works very much the same way, but it doesn't need the court's approval and therefore does not need to be considered just and equitable. Both are completely viable solutions, but we do recommend you get legal advice on both. Obviously, if you can't come to an agreement, that's when matters tend to head to court, which obviously isn't preferable for anyone involved. And therefore it's important to be upfront with the assets you have so that you can determine how you're best to split your assets and liabilities between the two of you. That's about all the information we have for today. It's short and sweet. If there are any questions, they can be directed to our office or leave a comment below and we'll do our best to get back to you. Thank you.